Mr. Strant has been reimbursed, paid salary, repaid for loans, and then some. Thus, the company is at a loss to understand the basis of the breach of contract claims, much less the first amended petition, adding fraud, exemplary damages, and other claims. So, Your Honor, I'll turn first to the fraud claim. Let's look just at the pleadings. Go ahead.
So this has already been ruled on once, right?
Correct, Your Honor.
And what was the original ruling on this?
Dismissing all of the claims on which we moved: fraud, exemplary damages, the indemnity advancement of fees claim, and the shareholder inspection claim.
So you won these issues with the associate judge.
Correct, Your Honor. And
then this has been an appeal made by the other side, correct?
Correct, Your Honor.
So I guess why are you arguing this first? Because I guess it's a de novo hearing.
Yes, Your Honor, because it's a de novo hearing. That is what what at least I thought we were going to do. But Your Honor, we can answer your questions. We can handle this another way.
And Your Honor, that was my assumption as well, because it was a de novo hearing. I assumed we would be starting over, but we are happy to handle this however you would prefer.
I guess it's really up to y'all. I see this as kind of an appeal, so there's going to be obviously some level of deference given to the associate judge on this. So whoever is arguing, are you on the other side, Ms. Shillette?
Yes, Your Honor.
If you want to argue this, or Mr. Castaneda, or whoever wants to argue this, I think it kind of makes more sense to me if you did that.
Sure, we will begin. Your Honor, as you are well aware, a party moving for dismissal of a claim under Rule 91A bears a very heavy burden. They have to show that the claim that is being challenged has no basis in law or fact. And at the intersection of that standard is Texas's liberal pleading standard, which provides for fair notice. A plaintiff is not required to marshal all of its available evidence or to prove its claim in its petition. And further, Texas law provides a mechanism, special exceptions that we're all familiar with, that can be filed if a defendant claims it cannot understand the allegations of a pleading.
What was Judge Munoz's reasoning if she said in the underlying argument hearing?
Your Honor, there was no reasoning that I remember from the hearing. It was the hearing was argued, and then we got an order a few days later, I believe.
Okay.
So again, there are fair notice pleading. We have special exceptions if there's something that the defendant does not understand about a claim. And here, when you look at the motion to dismiss, it's clear that the defendants understand the claims against them, and that their motion to dismiss really reads like a very premature summary judgment that simply ignores the plaintiff's allegations. As Ms. Sabisky was saying, this case, it isn't only, let me start. She says it's an accounting case. It's more than an accounting case. My client was the CFO of E3, and he was ousted, as she said, in December of 2023. At the time of his ouster, there were certain amounts that he had not been paid by the company. And there's 4 buckets of those, Your Honor. There are charges on his recent credit card statements that were not reimbursed. There were some advances he had made to the company because the company did not have enough money in its account. There was a large component of back pay. And then there was another expense that was on the credit card, but I'm treating it differently because it was for a rental car, and it's a bit of a separate issue. But those are the buckets for which Mr. Strant had not been paid, and he said at the time of his termination, pay me these. And that's when E3 came in after the fact and said, we're not going to pay you these. We want you to explain all of these accounting entries. We want you to back up everything. And we're not talking about just things that they reasonably believed were personal expenses and there was some confusion on. We're talking about hundreds and hundreds and thousands of entries that were clearly company. He was accused of, paying for a suite at a concert that was a business expense, and they said it was personal. When there's text messages, they know. So what happened at the time of his ouster is he said, pay me. And they said, we're not going to pay you because we're not going to reimburse you unless you tell us all these things. So they commenced an investigation. They hired Ms. Zabiskie. They started asking him for information, and that led to him hiring us. And that's kind of the backstory of how we got here, is the accusations that Mr. Schrant had done something wrong. And in the face of not being paid in those accusations, he had no choice but to file a suit to try to get paid. Now, here, the motion, the 91A motion, should be not denied in its entirety because plaintiff has properly pled the causes of action that are challenged. And those are a fraud claim against Mr. Scoble, Mr. Porter, and E3, a breach of contract claim for advancement against E3, and a violation of his statutory rights as a shareholder that's pled against E3. And there's a valid basis in law and fact for each of those causes of action. Now, Your Honor, I want to start with advancement because advancement is an important issue. As we all know, the ultimate purpose of advancement is to protect a corporate officer or director, whoever's being advanced, their personal financial resources from the significant expenses and proceedings that are resulting from the official service. And advancement is really important, and it's different from indemnity because it provides the corporate officer with immediate interim relief from those expenses. And what you'll see, Your Honor, from our pleading is that E3's bylaws provide for mandatory, broad indemnity and advancement. And Mr. Plotkin, if you can pull up, I want to show the portions of the pleading, Your Honor, that are at issue. If you look at paragraph 23 of plaintiff's first amended petition, you'll see the language. Is it kind of?
I'm unable to share screen.
Oh,
Is
give me a
there
second. Yeah, I'll enable that. Go ahead.
If
Here
you
we
look
go.
at
So the first, let's go through cause of action by cause of action. The first one is advancement. I've not heard of that as a cause of action. So
let me be more precise. It is a breach of contract for failing to advance fees is one of the challenged causes of action.
and is that something that Judge Munoz dismissed?
Yes, Your Honor.
Okay.
And it was Judge Craig, I believe.
Judge Craig, okay.
Yes, Your Honor. So I want to start with the advancement, the breach of contract claim for advancement. And if you look at our paragraph 23, we plead what E3's bylaws provide with respect to indemnity. And you see that it is a very broad indemnity for any person who was or is a party or is threatened to be made a party to any threatened, pending, or completed action or other proceeding. And you see some listed there: civil, administrative, investigative, or any inquiry or investigation that could lead to such an action or proceeding by reason of the fact that the person is or was a director or officer of the corporation. And it goes on, Your Honor, against all judgments, including reasonable and necessary attorney's fees. Now, the next paragraph, 24, is where we talk about the advancement provision that is related to what is set forth as a proceeding under the indemnification. And you see where paragraph 24 says the E3's bylaws provide the E3 shall pay or reimburse reasonable expenses incurred by a covered person who was or is a party or is threatened to be made a party to any proceeding in advance of the final.
So what you're showing me is not a cause of action though, right? That is just, you're just quoting from the fact section, I guess.
Correct. I'm showing you the teeing up of the cause of action. And this is just what bylaws provide, which is that in advancement here is mandatory, as you see the shall term used. It covers former officers such as Mr. Schrant, and it covers many different types of actions. It's not just limited to lawsuits. It includes investigations and inquiries. And as we know from the Home Store versus Tiffin case, that was a Supreme Court of Delaware case cited in the briefing, advancement applies even to internal investigations. It covers threatened proceedings, and it covers those former officers who were made a party to any proceeding or were threatened to be made a party. Now, I do want to look at the other allegations. If you look at paragraph 21, that is where we begin detailing the claim for the indemnity and advancement, or at least the factual support for that, which in paragraph 21, we say, beginning in December 2023 and continuing to the present, E3 has accused Schrant of paying for personal expenses with company funds, demanded explanations of E3's accounting records as part of its internal investigation, and asserted that Schrant owes sums to E3. Paragraph 22, Your Honor, is where we detail that Mr. Schrant complied with the bylaws and demanded indemnity and provided.
Okay, let's skip ahead a little bit. Let's go to where the cause of action itself.
Sure. The cause of action itself is, let me get there, Your Honor.
So,
There's a few, I'm sorry. It is our count 11, which is breach of contract against E3 for advancement.
okay. Ms.
And-
Sabisky, what is your response as to advancement?
Your Honor, on advancement, I'm going to skip past some of the introduction just to note that it wasn't tied back to the pleadings, but let's focus on advancement, right? So we heard from Ms. Shillette about general thoughts about how advancement work, but what really matters here, of course, is whether they have made a claim and alleged a claim under Texas law, whether there's a basis in law. So first, we can't look at the bylaws in a vacuum the way that they want us to, right? So indeed, the bylaws themselves expressly state, and here we're quoting their response at page 5 in paragraph 23, to the fullest extent permitted by the Texas Business Organizations Code. So now you look at the Texas Business Organizations Code, right? At section 8.004, it says valid only to the extent it's consistent with this chapter. At section 8003, bylaws can restrict the circumstances under which the enterprise must, or may indemnify or advance expenses. And the Texas law is confirming the statute is a ceiling for bylaws under Texas law. That ceiling then expressly states that advancement of fees is only available to a respondent or a defendant. That's at the Texas Business Organization Code at sections 8.103 and 8.105. And while I agree that there wasn't a lot of discussion at the hearing on reasoning, there were specific questions about this. And Judge was, I think she expressed in her questioning some concern about the fact that these bylaws, the Texas Business Organization Code clearly says that advancement is not available to a plaintiff suing his company. But let's look at the bylaws in a vacuum for a section. It's not proper, but even if we do that, right? Advancement still only applies where indemnity could apply. Looking again at the bylaws quoted in paragraph 23. Right? So it's the bylaws indemnity requirement that includes advancement. We can't separate those two. And the Texas Business Organizations Code is clear that a company can't contract to advance fees to someone who's not aligned with the company. This is at section 8.102, permissive indemnification. And I'm not going to read the whole thing. So it starts, an enterprise may indemnify a former governing person if it is determined in accordance with section 8.103 that the person reasonably believed that the person's conduct was not opposed to the enterprise's best interests. Not surprisingly, plaintiffs hasn't identified any case in which a defendant is required to indemnify the plaintiff suing the defendant, because there isn't one, right? Because
this is for advancement of attorney's fees.
Correct, under an indemnity.
Okay, I misunderstood. I thought she was saying it's advancement of expenses.
I believe it's both, Your Honor, but it's definitely fees is the issue.
I mean, I'm sorry, not legal expenses, but reimbursed, non-reimbursed expenses.
Yeah, no, this is about legal fees and costs, Your Honor.
All
Correct.
Right.
I agree.
All right, I'm going to sustain the ruling of Judge Craig on this point. Let's go to the next one.
The next point, Your Honor, is on the fraud claim. You heard a little bit about E3 being a startup company. The company's founders all agreed to forego traditional financing like pursuing a bank loan or line of credit and instead relied on Mr. Schramp's credit. They did that for a few years until around the fall of 2023 when Mr. Scoble and Mr. Porter in secret decided to oust Mr. Schramp from the company and decided that E3 would no longer reimburse Mr. Schramp for expenses charged to his credit card. Mr. Scoble and Mr. Porter also allowed Mr. Schramp to advance funds to E3 after they had decided to oust him and knew that they would not authorize the company to repay Mr. Schramp for that loan. There are three arguments that the defendants make alleging dismissal of this claim, Your Honor, and I can tie these.
Can you show me the actual claim on here?
Yes, Your Honor. Let's go to paragraph 37. And the first argument that the defendants make is that defendants argue that plaintiff did not allege a duty to disclose, and that is absolutely incorrect. If you look at our paragraph 37, you see where we do have that allegation. Scoble, Porter, and E3 had a duty to disclose.
Is that the position of the defendants, is they didn't have a duty to reimburse him for business expenses? I didn't understand that to be the case.
That's not the case, Your Honor. We agree that there is an unwritten agreement to reimburse Mr. Strand and any officer or employee for reasonable and appropriate business expenses. The dispute here is just whether or not he's already been paid. And our point on dismissal of the fraud claim is it's just a restatement of a breach of contract claim. It's just
that is what it. Yeah, Ms. Shalott, that is what it sounds like. Do you have anything?
Well, the three arguments they make are that there was not an allegation of a duty to disclose, that Mr. Strand did not allege that he was ignorant of the facts or lacked an equal opportunity to discover them, and that defendants also claim that plaintiff did not allege fraudulent intent. If you look at paragraphs 37, 38, and 36, you see all of those required elements of the claim. It is not simply a restatement of a breach of contract, because if you look, they want to focus, the defendants want to focus on timing and try to make all these confusing arguments that Mr. Schramp was the CFO and he had control of these accounts. So how could anybody do anything that he wasn't aware of? But Your Honor, the expenses that are the subject of the fraud claim are limited. They're not the back pay. They're not old expenses for which he's been reimbursed. They are simply expenses from his credit card that were incurred in the fall and winter of 2023, and an advance that he made at that time. And that was the time that Mr. Scoble and Mr. Porter decided they were going to oust him, and they were going to change the reimbursement policy. This is a new transaction where he's incurring additional expense. It hadn't happened in the past, and he should have been told, we're going to oust you from the company and we're not going to reimburse you anymore. That's how it's different, Your Honor. It's the timing. They knew and they had a duty to disclose. He's operating under incorrect and not full disclosure of the policies and procedures, and they changed those on him. And then they try to use it as a gotcha.
I'm going to go ahead and sustain the ruling of Judge Craig on this. What's the next one?
The next one, Your Honor, is the books and is, well, there. To be fair, there was an exemplary damages count as well that would be addressed by your rulings on the fraud claim. So I'll move on to what was the last issue, which is we had pled a books and records violation because Mr. Schramp had made a post-litigation request for books and records. In their motion to dismiss, defendant E3 overreaches and says at, I believe it's page 3 of their motion to dismiss, a shareholder has no right to inspect books and records from a company he has sued. That is not Texas law. That is not Delaware law. It is a gross overstatement. Defendant has a statutory and common law right, or a statutory and common law obligation to allow a shareholder to inspect the books and records. And as the cases that we cite in our response show, it may ultimately be necessary to inquire as to whether there is a proper purpose in ultimately deciding the claim. There's no absolute bar, as the defendants here suggest. the pleading alleges a proper purpose and the parties can engage in discovery on that issue, or defendant can pursue special exceptions, but dismissal is not appropriate under the circumstances in the pleadings.
Ms. Zabiskie?
Your Honor, you cannot, the only allegation is literally the words "a proper purpose." There's no proper purpose that has been alleged. So the entire factual allegation actually just says "despite proper request," and then the legal allegation simply says "stated a proper purpose." That's a threadbare recitation of the elements, and that fails to allege a basis in law or fact for the inspection claim. Additionally, we produced all the books and records 3 days after this claim was filed, months ago, April 3rd. So, I mean, on the pleadings, we have nothing but a bare recitation of the elements of the claim, and that is enough to dismiss this. That's
Unfortunately, I'm going to overrule Judge Craig on this point.
Okay.
So, if you could go ahead and prepare an order for me, Ms. Shillette, go ahead and say that this was heard on Zoom on August 12th, 2024. Make sure you share that with Ms. Zabiskie. Excellent arguments on both sides. And get that to me if you can by tomorrow morning.
Thank
Yes.
you, Your Honor. We also request fees to be determined at a later hearing, given.
Denied.
Okay. Thank you, Your Honor.
Anything else?
That's all.
All right, guys, you have a great rest of your day, and we'll see you on the next one.
Thank you, Your Honor.
Thank you, guys.
Thank you, Judge.